it's a pleasure to welcome Anja von Rosenstiel to moderate this panel. I'd like to say a few words to introduce her. Anja von Rosenstiel is an accomplished attorney at law and mediator with extensive experience, especially in the fields of banking and finance. She currently serves as counsel at a German law firm and as a faculty member at Boston University School of Law. Anja von Rosenstiel has greatly contributed to the global discourse through her writings on mediation and blockchain law. Given her expertise in alternative dispute resolution methods, I'm confident that she will bring valuable insights to the discussion. Anja, thank you very much for agreeing to moderate this panel. The floor is yours. Thank you.
Thank you, Florence. I'm very excited to be here. So I have the honor to introduce our panelists this morning. So I start with you, Sabrina, on my right. Sabrina, you are not only a practitioner doing every day what we are discussing today, but you bring also a specific knowledge in e-communication to this panel. You are an associate professor at the University of Teknikal, Malaysia, right? Okay, sorry, I misunderstood. Sorry, but you have a BA in Communication and Sociology, that is correct, and an MSc of University of Oxford in Social Science. So you're an expert in communication, and you are a member of the, or let's say a senior case officer at the Meta Oversight Board, right? So welcome to this panel. And then we have Marie-Caroline Arreto online. She's a professor of public law at l'Institut Catholique de Paris and has a doctorate from University of Paris 1. Even has been doing research at Max Planck Institute in Germany and is a known scholar for constitutional law and a specialist in fundamental rights. So welcome to this panel. And then we have Sophie Weerts, welcome as well. You are a professor at University of Lausanne and have published widely also in EU regulation of technology and lately also AI, and bring a lot of knowledge in tackling the question how to best regulate technology while holding or upholding fundamental human rights, right? So I'm very excited to open the floor to who goes first? Sabrina, I think, to listen to your presentation first, and then we go through the presentations, and then at the end we have a discussion where we're happy to have a Q&A, right? So you go ahead. The floor is yours, Sabrina.
Hi, good morning, everybody. Can everybody hear me okay? Okay, perfect. Thank you so much for joining us today. Et merci à l'Université de Neuchâtel et l'Institut Catholique et aussi à Professor Guillaume pour m'accueillir aujourd'hui. So today I'm really excited to talk about the Meta Oversight Board and its relationship to human rights. Before I get started, I wanted to see how many of you have heard of the Oversight Board before or maybe familiar with it? Can you just show me some hands? Oh, okay, great. Fantastic. Usually when I speak to some people, they've never heard of it, so it's fantastic that you have some foundation. So I'm very excited to speak about the board today, the work that we do, and its relationship to international human rights as a framework for moderating content on Facebook and Instagram. So I've basically broken down this presentation into two parts. The first is just going to give a general overview of how the Oversight Board moderates content on Meta's platform, so that's specifically Facebook, Instagram, and recently Threads, which is very exciting from a scope expansion perspective. So my hope is that even if you are familiar with the board, you may learn something new about how the board operates or kind of the intricacies of the board. So I'll talk about the purpose and history, give a general overview of the case selection and review process. So how do we choose cases? How do you as a user submit an appeal to the board? And some of the key impacts. And then the second part of this presentation is going to be talking about how the Oversight Board implements international human rights principles into its decision-making process. So we'll talk about how international human rights is actually baked into the very foundation of the board from its conception. We'll also talk a little bit about corporate versus state responsibility. I know that my esteemed colleagues here today are going to talk about that a lot more in depth, so I'll only kind of briefly discuss that. And then I'll do a very brief comparison of the Oversight Board to Human Rights Tribunal and kind of the opportunities and the pitfalls of that kind of model, a consent-based model. So firstly, what is the Oversight Board? So fundamentally, the Oversight Board is here to promote free expression by making thorough, principled, and globally relevant decisions regarding content on Facebook and Instagram by issuing recommendations on relevant meta content policy. So this was actually a board that was created by Mark Zuckerberg himself. It was initially, the idea started kind of permeating around 2018, and then the board actually came into fruition in 2020. And who you see here are the 23 board members currently working at the board. Just to highlight a couple of people here, we've got Helle Thorning-Schmidt, who is a co-chair. She's the former Prime Minister of Denmark. We've got Alan Rusbridger, who is the former editor-in-chief of The Guardian in the UK. We've got Tawakkol Karman at the bottom there. She's a Nobel Peace Prize winner from Yemen. So we've got a very wide breadth of individuals across a range of areas of expertise, ranging from international human rights law, to journalism, to constitutional law in the United States, to politics and government. So we've got quite an esteemed group of people here working on the board, which I'm very proud of personally. And what do I do? So very quickly, I'm a senior case screening officer at the Oversight Board. So we have the 23 board members that make up the board, and then we actually have administration staff of around 60 to 70 people across the United States and across the UK who support the work of the board. So I joined the board in 2021 when we were roughly about 20 people, and we've actually tripled in size since then. And my primary role is to actually help select the cases that the board receives and eventually adjudicates. So if you've ever read any of our transparency reports, we receive about 1,000 appeals a week. To date, we've received over 1 million appeals. And so we have a team of people that actually is the first point of contact with the appeals to try and find the ones that are going to be the most emblematic, that are actually going to address interesting policy considerations for Meta. And just to give you an idea of how robust the administration actually is and all the work that we do to support the work of the board, the different kind of cross-functional teams we work with, we've got legal, policy, we have a data implementation team to make sure that when we make recommendations to Meta, they actually implement those recommendations in a way that are quantifiable and verifiable. We also have a program management team that makes sure our case timelines are on track, and we also have a communications team that does a lot of external stakeholder outreach and a public comment process as well. So that gives you a little bit of an inner lens into the work that happens behind the scenes. And I wanted to talk a little bit about independence and transparency, because this is a question that we get a lot, is how independent are we actually as the independent Meta Oversight Board? So firstly, this may not be common knowledge, but we were actually established as an irrevocable trust. So we're an entirely separate, independent financial institution from Meta. We actually have entirely separate offices. So we do have offices in the US and the UK, but they are not in the same offices at Meta. We've got separate buildings. Our board members nor the administration, neither of us contract with Meta directly. We have our own separate financial and contractual agreements with the board itself. Meta has no influence over the board's decisions. So from the moment that we receive a case to the moment that we make a recommendation or a decision as to whether a piece of content should be removed or stay on the platform, Meta has no intervention in that whatsoever. Meta can send us referrals, so it has happened many times where Meta will send us a case that they think is interesting, but it's entirely at the board's discretion to choose whether or not we decide to take that case. Typically, we do like to take those cases because that usually indicates that it's a problem area from a content policy perspective, and so it's something that we think is valuable to take on, but we don't always take a case from Meta. And ultimately, our key mandate is to make binding decisions that aim to uphold freedom of expression and improve the application of global human rights standards on Meta's platforms, which I will get into later in the presentation. All right, so the case review process. So how many of you are active users of Facebook, Instagram, or Threads? Great, okay, awesome. So basically, I'm going to take you through what the appeal process would look like if, let's say, you were an Instagram user who wanted to appeal a piece of content. So let's say you're an Instagram user and you are posting something about a war happening in some country, and your content gets removed from the platform. So the first step is that you appeal to Instagram. And so the first step is that you appeal to Instagram, and Meta, or Instagram in this case, denies your appeal. So what happens is when you have your appeal denied, you receive a reference ID specifically for the Oversight Board. So what happens is then you can take that reference ID and appeal to the Meta Oversight Board directly. Or, as I've mentioned in the slide here, Meta itself can also appeal to the board. Then what we have is we have a case selection committee that decides whether or not to select or deny the case. And this is published in our transparency report, so I am going to make note of this, that in all honesty, the likelihood of your case being selected is a little low. This is because we are specifically, rather than volume, looking for the most emblematic and pressing human rights cases. So a lot of the cases that we receive are not meritorious, and so we do only take the very select few that will have the greatest impact or the greatest possibility of making a difference on Meta's platforms. So there's a case selection committee of 5 board members that choose whether to select or deny the case. Once the case is selected, it's actually assigned to a different panel of 5 different board members who will adjudicate the case over 90 days. The board will then also post a description of the case online, so if you are interested in the case, you can actually, anyone is able to submit a public comment, and that's open for 14 days. The panel makes a decision on that case is the next step, and the entire board actually has to vote on the decision. So there have been times where a case needed to be re-examined or re-voted because not enough board members agreed with the initial decision of the initial panel. But once there is agreement on the decision, we publish the decisions on our website, and you can read all of them. And these are, I'm just going to very quickly go over the different decision types because they are slightly different. So the first is a standard decision, which is about 90 days. We have the expedited decision, which is usually instead of the 90-day process, we actually try and resolve the case within a couple of weeks to a month, which is in our case considered quite expedited. We have summary decisions, which I personally think are very interesting, but I don't think get enough attention of the board. And these are instances where Meta admitted that it had made an enforcement error on the platform. So it had taken down a piece of content that it then reinstated after our intervention, or the opposite, where it failed to take down a piece of content until we intervened and said that this shouldn't be on the platform. So what we do with these decisions is we write a very short 2-page summary stating what happened and reinforcing the need for the board to kind of intervene in ensuring that Meta actually follows its proper community guidelines and enforcement procedures. And then finally, you have a policy advisory opinion, which is a very long, usually a year-long process where we examine a topic in depth. So for example, the use of the word shaheed, which means martyr, and how that's being used or maybe over-enforced by automated systems. We also looked at how Meta handled the COVID-19 crisis from a content moderation perspective. Okay, so very quickly, the impact as a result of the board. So all of these might seem obvious to you at first glance, but these were actually all things that came as a result of the board being created and making recommendations. So the first is that Meta launched new user notifications to make them aware of when automation was involved in a piece of content. The second one I think is my favorite because, again, I think it's just something that would seem so evident at first glance but actually wasn't being done until the board came. Which is that Meta's translated its community standards to dozens of new languages, for example, Punjabi, which didn't exist before one of our case decisions, which has more than 30 million speakers in India alone and is a very large market for Facebook and Instagram. Meta published a human rights report of its impact in Israel and Palestine as a result of one of our recommendations, and it also updated its strikes and penalty systems and reduced the restriction times to make it less punitive on users. So if you've ever been in Facebook jail or Instagram jail, this is what it's referring to. And these are our 7 strategic priorities. So typically when we take on a case, we try and do it across one of these kind of thematic priority areas. So I lead the gender strategic priority, but we have these 7 different ones here. And they kind of came as a result of 2 different avenues. The first being a lot of stakeholder engagement we did with civil society and advocacy groups. And the second was just looking at the trends of the different kinds of cases that we've accumulated over the past 3 years and trying to understand what trends are emerging, what can we try and coalesce around. So these are the 7 strategic priority groups that we try and choose our cases around. And these are some of our major case decisions. So I actually was speaking to someone last night at dinner, and he was saying that he didn't know that one of our major cases was the Trump decision. So I think this is one of our most iconic cases. So following the insurrection on January 6th, President Donald Trump's Facebook account was suspended for violating Meta's violence and incitement policies. So Meta actually referred the case to us and asked us, did Meta make the right decision in suspending his account? And so that was one of the major kind of keystone decisions that cornerstone, decisions that we made. We've also taken, again, a very broad range of cases from countries like Myanmar, Afghanistan, Ethiopia, many countries in Europe as well, across different community standards. So here you'll see hate speech, dangerous individuals, violence and incitement. We've also done cases on suicide and self-injury, sexual solicitation, adult sexual exploitation, child sexual exploitation, and many more. So the range of the board over the past 3 years has been pretty broad as well. And okay, so I'm excited to talk about this, particularly given the audience and the panelists that we have here today. So what is the relationship between the Oversight Board and international human rights? So as I mentioned at the top of the hour, international human rights and Meta's Oversight Board's commitment to human rights is baked into the very foundation of the work that we do. So in our charter, which is kind of like our governing document, along with our bylaws, we've explicitly written that we pay particular attention to the impact of removing content in light of human rights norms protecting free expression. So in many of our case decisions, if you've read them, you'll see that the board has described itself in many of those decisions as an independent, non-judicial grievance mechanism for users to appeal content decisions that have been made, which did not really previously exist before the board came to materialize. And the question that we ask in every single case decision is, are Meta's community standards and guidelines regarding this type of content consistent with international human rights principles? So if you open any one of our case decisions, you'll have the tripartite test from Article 19 of the ICCPR, which is legality, legitimate aim, and necessity and proportionality. So for anybody who isn't familiar with this, legality doesn't actually mean was this content legal or not. Legality actually refers to, according to Article 19, were the rules clear? To an everyday user who posted a piece of content and, let's say, had it removed, was it clear to them in the first place what the rules were regarding what could be allowed on the platform and what couldn't? So that's the first part, is were the rules clear? The second part is legitimate aim. So if the content was removed or there was a contravention on the freedom of expression, was it for a legitimate purpose? The third part of the tripartite test is necessity and proportionality. So if it was clear that the rules were, there was legitimate aim, was it necessary to contravene freedom of expression? And if it was the contravention or the removal of the content proportional to the piece of content and the community guidelines? So those are the three parts that every case decision that the Oversight Board publishes will examine. And Meta's human rights obligations and the Oversight Board. So again, I won't go into this too much in depth because we have some experts here today who are going to talk about that quite a bit more. But I will talk about this specifically with regards to the Oversight Board and Meta. So for anybody who wasn't kind of sure about the distinction between state obligation and corporate responsibility, governments have legal authority and sovereignty over a given territory, making them responsible for protecting and upholding fundamental rights and freedoms. Corporations, however, such as Meta, are private entities with no inherent legal obligation to protect freedom of expression. Some companies like Meta can voluntarily subscribe to the United Nations Guiding Principles for Businesses, which has certain kind of guidelines on how to respect freedom of expression, but there's no inherent legal obligation for them to do so. And this is where the board is kind of a very unique player in the field. So the board itself seeks to provide accountability and remedy in ways that would be considered unique in the field of social media. So the board's individual decisions are binding on Meta. And I would like to caveat that a little bit. So the decision as to whether a piece of content should be staying up on the platform or should be removed from the platform is binding on Meta. With our contractual agreement, Meta is required and obligated to follow that decision. However, with every case decision that we make, we also provide like accompanying policy recommendations as to how Meta should modify its community standards or its decision-making processes or enforcement procedures. Those recommendations are not obligatory. Those are not mandatory for Meta to follow. In many instances, they do, but those are not necessarily mandatory for them, and I'll give you a very good example of one of the very high-profile cases in which Meta rejected our policy recommendation. And then the Oversight Board's operational and financial autonomy contributes to its effectiveness as an operational level grievance mechanism under Principle 31 of the UNGP, so the United Nations Guiding Principles. I will say, again, a question we get a lot is, how independent is the Oversight Board from Meta? one of the things is we are financially independent in the sense that we are operated by a separate trust with our own trustees. Our funding does come from Meta every 3 years. And from a technical perspective as well, we share engineering teams as well. And also there are certain privacy agreements with Meta that we have to follow. So we are in some ways inextricably tied to Meta, but we are independent to the extent that we can be. And I'm happy to discuss that later as well with anyone who's interested. And my last slide is just comparing it to a human rights tribunal, so the advantages and limitations. So the board is the only independent body that has real contractually binding authority over Meta. I know later today we'll have some sessions on the DSA, and so I know that as a result of this legislation, there may be some new out-of-court dispute resolution bodies that'll come into play, but I think what's interesting about the board is that we're the first one to really kind of exemplify this model, and so we can be an early leader in showing what works and what challenges might be ahead for these new bodies. Meta has implemented or committed to implement the majority of the board's recommendations, which is great, and overturned Meta's decisions 80% of the time. And I would also like to highlight that I do think that there is something to be said for agreeing with Meta's decisions 20% of the time, because if they were wrong 100% of the time, I think that would be a much larger issue from a content moderation perspective. So I do think there is value in reaffirming Meta's decisions some of the time as well. And what are the limitations? So firstly, I think the biggest kind of elephant in the room here is that Meta has not actually implemented all of the board's policy recommendations. So the one that I want to call out is the Cambodia case that we took, in which former Prime Minister of Cambodia, Hun Sen, exploited Meta's platforms to incite violence against his political opponents in the recent election in Cambodia. And the board had suggested from a policy recommendation that Meta suspend his account, suspend his Facebook account. And Meta rejected that policy recommendation on the grounds that it was not consistent with their social media and content moderation protocol. We suspect that there may have been other issues at play. So for example, safety. It's not maybe something you would immediately think of, but if Meta has employees on the ground in Cambodia, banning the prime minister of that country may have adverse impacts for the employees on the ground. And there's also geopolitical concerns. So if you think about it, a lot of the global south, and particularly Southeast Asia, is a very large financial market for Meta. And so there may be an issue from a financial perspective. So that leads me to my second limitation, which is that ultimately, Meta is still accountable to shareholders and stakeholders, and so that might be a challenge implementing human rights as a framework when you have those competing interests. So that concludes my presentation. Thank you so much for listening, and I'm happy to take questions later with the rest of my panelists. Thank you so much.
Thank you, Sabrina. That was very insightful. Next up, we have Marie-Caroline Arreto joining us online. So, Marie, the floor is yours.
Thank you, Madam Chair. Many thanks to the organizers for the invitation, and especially to Mrs. Florence Guillaume and Mr. Constantino Leonel Ferreira. Sorry for not being physically present, but thanks to technology and to the wonderful team of SwitchProd, I can be partially present. My intervention consists in questioning the effectiveness of moderation through fundamental rights. Before getting to the heart of the matter, the formulation first requires clarifying the terms. We can then tackle the question of effectiveness. First of all, what is the problem we face here on the moderation of content published on social networks? It will have escaped no one's notice that the possibilities for exchange have in a certain way increased tenfold with the development of the web and what we have called from the 90s, the new information and communication technologies. With the appearance of social media, which notably allow for more widespread individual expression, not a day goes by without a moderation problem being raised, whether for fear of misinformation in times of health crisis, elections, or war, or whether in interpersonal relationships. Moderation has therefore become the central issue of good civility on networks that some characterize less and less as social. But in the daily use of these tools and moderation in action, it is possible that moderation errors appear. These errors are generally correlated with automated moderation. This is why it seems important to me to emphasize a principle contained in the General Data Protection Regulation, which had previously been enshrined in French law, namely the need for a decision not to be entirely taken through an automated process. Moreover, in application of this principle, the DSA recognized the need for platforms to give users of these social media a right to contest the moderation of any content that led to its withdrawal. The question arises as to how this moderation is legally regulated. After all, the platforms providing these social networks are private operators, and unless this moderation is imposed by the legislation of the state of origin or the state in whose territory the network is accessible, nothing obliges it to exercise this type of moderation, exception made, of course, to respect the law. The term moderation is ambiguous because it refers as much to content considered illicit as to content evaluated from the point of view of a certain civility or even certain cultures. Depending on the cultural background in which the users find themselves, friction is likely to appear between them, with the sole explanation being their way of saying or seeing things. Here we can think of the very direct frankness of the American or the Germans, the flame of the British, or even the multiple taboos that exist in French people. An additional difficulty in understanding the meaning of the notion of moderation is that researchers often depend on primary moderation data from the platforms themselves, and that the categories must already be the subject of explanation before they can be used in a study. Researchers in communication and information sciences from the University of Bremen have attempted to create a typology of moderation cases on the main social media platforms: YouTube, Facebook, Instagram, TikTok, Pinterest, Snapchat, X, and LinkedIn. To narrow the scope of the study somewhat, the team limited its study to a period of 24 hours. If private operators detail cases of moderation more or less rigorously, it is interesting to note that the team identified 14 categories of moderation. We can distinguish 3 groups for those kinds of categories. First group, the cases provided by the law, that means data protection, intellectual property, pornography, public security, illegal or harmful speech, scams, and fraud. The second group is the cases of civility specific to any citizen's community: civic discourse, non-consensual behavior, protection of minors, self-harm, animal welfare, unsafe products, and violence. The third group is all the cases provided by the condition of use of the platform, that is to say, the scope of platform service. The study goes on to classify platforms according to these types of moderation, which for sociologists could greatly help establish which sociological categories use which platform. From a legal point of view, we see that moderation applies to a first case circle of pure legality, with more or less strong normativity, that is to say, general and abstract provision or equivalent of internal regulations. And then there is a second cases circle of minimal civility, which is also included. Still, according to this study, if moderation applies to all types of content, the reader is struck by the fact that the proportion of the category mentioned as other used by the platform themselves contains twice as much moderated content as the all categories combined. EI, text, images, videos, audios, etc. In light of the study data, however, it is not possible to precisely define this category referring to other moderate content. So the term moderation is not easy to define and delimit in relation to its various applications. As a jurist, it is also important to consider the question of knowing according to which standards this moderation will take place. And this is where the proposal takes on its full meaning. A certain framework that would make this possible would be that of fundamental rights. It will have escaped no one's notice that the area that interests us concerns digital technology, and these are several answers to the question on how fundamental rights apply in digital technology. The first response is to consider that the law applies in the digital domain as it can apply elsewhere. In this hypothesis, the applicable text will be the various national texts, the American Declaration of Independence, the Bill of Rights, the Declaration of the Rights of Men and Citizens, etc. But also regional texts, for instance, the European Convention for the Protection of Human Rights and Fundamental Freedoms, the Inter-American Convention on Human Rights, or even international texts, such as the Universal Declaration of Human Rights. But some authors defend the need to develop a text of fundamental rights specific to the digital domain. Moreover, my colleague Arnaud Latil has listed the various text proposals that appeared between 2010 and 2020. In this work, if this work is partially obsolete, or on the contrary, far too prospective, it is interesting in particular to identify which fundamental rights should appear among reference standards in content moderation. Arnaud Latil identifies 4 groups of rights and freedom that are particularly present in those texts. The first group belongs to the right to equality and non-discrimination. The second group, the right to privacy. The third group, the right to knowledge and mastery of digital techniques. And the fourth group, the freedom of expression. In addition to the fact that these 4 groups show that not all fundamental rights will be relevant in a content moderation, this makes it possible to target as closely as possible the concrete reality of the moderation issues. At first glance, there is a tension in this project of wanting to moderate in relation to fundamental rights. In fact, the difficulty here is that this object necessarily calls for state intervention. Indeed, if non-state authorities, whether international, regional, or local, are likely to give effect to fundamental rights, this delegation is generally organized by the state itself. While the idea of content moderation refers private operators to manage conflicts in the use of the tools made available by their own platform, the concept of fundamental rights reintroduces a form of verticality. In other words, if the moderation of platforms takes place outside the structures and institutions of the state, such as the police, the courts, there is in a way a reappropriation of state power. We have all in mind the example of the monopoly of legitimate violence, according to Weber. And this reappropriation of state power tends to be dissolved in this type of moderation. Platform operators have actually started to implement this type of moderation, particularly with regard to fundamental rights. This is the case of Meta's Oversight Board, a group of independent experts responsible for reviewing Meta's moderation decisions. Some members of the doctrine here in France has allowed themselves to succumb to a certain skepticism about the control of this body, which has jurisdictional characteristics without being a state jurisdiction. Moderation in relation to fundamental rights is justified in the decision of the Oversight Board by the idea of human rights responsibilities. As part of these responsibilities, the moderation bodies must verify that the fundamental rights of users of the platform have been able to ensure the effective exercise of their rights. These fundamental rights are contained in the UN Guiding Principles on Business and Human Rights, adopted by the UN Human Rights Council in 2011. In application of these guiding principles, private operators have a legal obligation to respect fundamental rights. But the authority of the United Nations over these operators being relatively weak, it is the responsibility of states themselves to ensure that these operators will apply this framework of fundamental rights. They will therefore have to intervene before moderation to ensure that private operators will carry out moderation that respect the fundamental rights enjoyed by platform users. However, this mechanism that seems to apply here to constrain these operators is the imposition by the state of the liability of the company. Under the threat of these acts, operators will be more inclined to respect their obligations, in particular that of ensuring users their freedom of expression. This approach is not the one that was adopted by the DSA, which entered into force in August 2023. In the explanatory memorandum, the text clearly specified that the responsible and diligent behavior of suppliers to enable other people to exercise their fundamental rights guaranteed by the Charter of Fundamental Rights of the European Union. But the main mechanism contained in the DSA is the one of transparency. That is to say, it treats only the effects of the moderation in a procedural way. However, it should be noted that some states, such as Turkey, for example, have also adopted this approach of liability of companies. Since July 2020, the Turkish government has amended its internet law to impose a whole series of obligations on social media companies. At the same time, we know that Turkey is not the best student in the Council of Europe when it comes to respecting the freedom of expression that all Turks must be able to enjoy. Turkey's numerous convictions before the European Court of Human Rights on the grounds of freedom of expression speak for themselves. If the procedural mechanism is therefore the same, that is to say, putting pressure on private operators by calling into question their liability in order to ensure that they will respect the rights of individuals who use their platform, the Turkish case can suggest that the result may not be the same as that of the EU or in United States. The management of moderation left to the operators themselves may have been the subject of criticism. Why should private operators reduce the scope of use of their own platform when this same platform is the instrument of their economic activity, which is an activity which only makes sense by letting people express themselves freely? What is interesting is that we see in the Turkish case that all the platforms have finally complied with the new Turkish regime, which notably required companies to appoint a local representative. Between the loss of a market in Turkey and the respect of this lesser obligation, the economic choice clearly prevailed. Although such control may appear relatively satisfactory, it is still necessary to agree on how to make fundamental rights a reality. How can we establish a substantial content of those rights that can be shared on a global scale? Here we come back to a central question in fundamental rights litigation. If fundamental rights are simply proclaimed, then their effectiveness is called into question. To take fundamental rights as a serious reference for moderation, it is also necessary that there exist remedies. In application of well-known jurisprudence of the European Court of Human Rights, the rights defined by the Convention must not be theoretical and illusory, but concrete and effective. It was the decision Airy versus Ireland. It is precisely in this state of mind that Meta has set up its system for regulating cases of contestation of moderation by creating this independent body made up of experts recognized around the world. The Oversight Board does not hesitate to adopt decisions that wrong the way in which Meta was able to moderate certain contents. And since the decision of the Oversight Board are binding on Meta, the latter has no choice whether to respect them or not. Of course, Sabrina explained us introduced a little bit of nuance here. The control mechanism seems to work since the credibility of the company's economic model is at stake here. On a purely legal level, we welcome that moderation remains a repressive regime in which only the use of freedom of expression is controlled. There is no a priori control, and the sanction only relates to the abuse of the freedom. By contrast, let us mention the Turkish case following the tightening of the law on the internet in July 2020. The courts with jurisdiction over moderation cases are not institutions which have a very keen sense of fundamental rights. It's state courts, of course. Moreover, the appeals before this institution are not likely to follow the ultimate procedural remedy, namely to be contested before the Turkish Constitutional Court. It is obvious that this exclusion of recourse to the constitutional judge generates a fortiori a reservation on the true use of fundamental rights to regulate moderation decisions. More generally, the question inevitably arises of how to organize appeal procedures against moderation decisions by the platform operator itself. Close to home, the decisions of the Oversight Board show the difficulty of conceiving the substance of fundamental rights. Briefly, let us mention the two relatively distant conceptions of freedom of expression in France and the United States. In terms of freedom of expression, the First Amendment is in fact the cornerstone of fundamental rights in the United States, which ultimately allows freedom of expression to be minimally regulated a priori. And the philosophy here is to oppose certain point of view, meaning that the confrontation of opinions is the core of the way expression is organized. On the contrary, France has a very ancient and more extended legislation to organize a priori the freedom of expression. Ultimately, the effectiveness of supervising moderation through fundamental rights depends largely on the design of this control and these rights. Which body will be responsible for carrying out this verification of respect for fundamental rights through moderation? Which conception of the fundamental right concerned will be retained and applied to the specific case? The effectiveness of such a framework depends largely on the purposes. If the control and conception of rights is purely formal, procedural, the framework of fundamental rights risks disappointing. On the other hand, if the operators agree on a more substantial purpose, it is possible that the supervision of moderation by fundamental rights will be satisfactory from the point of view of its effectiveness. Thank you all for your attention, and I'm looking forward for any question.
Thank you, Marie-Caroline, for this insightful presentation about the standards that could be applied to content moderation. And now we have Sophie Weerts coming up, talking about the relationship between states and social media platforms and balancing freedoms of expression online. The floor is yours.
Wonderful. Thank you very much, Anja, and thank you very much to Sabrina and Marie-Caroline for the already very interesting presentation. So before starting, I want to thank Professor Florence Guillaume for her invitation, and also all those who contribute to organizing this conference. I'm very happy to be back to Neuchâtel because I did my postdoc from 2015 to 2017 here in the University of Neuchâtel. It was a very important moment, I think, in my academic life. So in my intervention today, and considering that this panel is the first one of the day, I want to take an overarching perspective on these questions of human rights, social media platform, and dispute resolution. And from this perspective, my point will be showing that in the context of the European Union, we can see indeed kind of promotion of human rights-based approach, which have been adopted notably with the DSA. But on the other side, I'm a bit skeptical about the way that have been chosen for guaranteeing freedom of expression. So, to explain my point, I will, in the following 20 minutes, provide first some background perspective and research information on what I've been done with one of my assistant, Mathieu Fazel, which is there with us, and who's conducting his research dissertation on social media platform. Then I will give just very short information about freedom of expression and what does it mean in an online environment. And after that, I will highlight what I consider as the important regulatory changes that we have, that we get in the European Union. And finally, I will point out why I see the limit of the new limit of this system. So to begin with, and I will be short at what I've put on this slide. I think that you are not well informed about human rights law and international human rights law, but in a nutshell, what I think it's important in this case is that we have to keep in mind that in human rights instrument, you will have either substantive rights, such as freedom of expression, freedom of association, privacy, and so on. And on the other side, you will have procedural rights, or called also procedural safeguards or procedural guarantees. And if we have a look into these procedural guarantees, what we can see is that first it emerged in the context of criminal and civil law. And since the 1960s, it have developed in the administrative procedures. And this evolution of this enlargement of procedural guarantee to different kind of litigation means that now it's really a paramount principle from a legal standard. The second point that I think we should keep in mind is, in terms of human rights, is the fact that, first of all, human rights have been imagined or considered as something that have to protect people from the state. So it's what we have called the vertical effect of human rights. And nevertheless, since the 1960s again, the idea that human rights can also have an horizontal effect, meaning between private parties, has also been developed and recognized in some legal system. And on this specific point of this horizontal effect, the question was, so do we want to have binding instruments that impose the respect of human rights to, for example, transnational companies? And this debate happened in the United Nations in the beginning of the 2000s, but unfortunately it didn't it was not follow. There was a very strong resistance from Western liberal countries. But another option have emerged, and in fact, Sabrina already echoed this point in her presentation, is the human rights, the business and human rights solution with the UN guiding principle on human rights. And these guiding principles are what we call as in law soft law, so it means that they are not mandatory for transnational companies. Transnational companies are encouraged, incitated to respect human rights, but in fact they can decide if they want to do it or not. But since they decide to do it, then they start to, in fact, they have to do something. And one of the guiding principles that have to be implemented is this principle of having a remedy mechanism. And so, in fact, the Oversight Board that Sabrina already presented this morning is part of this solution. So I think these two elements are important for the purposes of this conference, because indeed, when we are talking about human rights and when we are talking about online platform companies, we are talking about transnational companies today. And so the question of if they are bounded or not by human rights is an important issue. I will not talk about a regulation study perspective. Maybe some of you will have questions later in the time that we'll have for discussion. But what I just want to say about this is that I think it's a very interesting analytical lens if you want or plan or are studying social media platform. So indeed, the analytical lens that we have used twice now in our research with Mathieu, first in this paper that we have just published in a Policy and Internet, and the second report that we have written for the Office Fédéral of Communication here in Switzerland. So regarding freedom of expression, just two things to keep in mind for today. The first thing that if you consider the offline environment, freedom of expression is the right to express your opinion, and this right is embedded in several international instruments. And it can have limitations, but these limitations have to respect the legal basis, the legitimate interest, and the principle of proportionality. And in a liberal democracy, usually if you have a problem due to the fact that someone uses freedom of expression, you will go to the judiciary to ask for this to stop this expression. And now, if you look to the online environment, what you can notice is that the judiciary or the state authorities have been replaced by social media companies. And this was possible due to a regulatory choice that have been posed in the 1990s in the US with provision 230 of the CDA. And this provision, in fact, guarantee social media companies that they won't be responsible for what have been posted online, so on the platform. The European Union followed more or less the same solution with the e-commerce directive in 2000. But nevertheless, even if we can think that from this perspective, social media companies were really free to do what they want to do, are not responsible for what's happening on the platform. Nevertheless, they self-regulate, so they regulate themselves, And they had two incentives to do that. The first one is because they had an economic incentive to keep people using the platform. More people are on the platform, more people stay longer on the platform, more data they collect on the user, and more money they can make with this data. The second incentive, in fact, it's a regulatory incentive. So far that they are managing the question, the potential problems happening on the platform, state legislator will not interfere on their activities. Nevertheless, this perspective or this conception of regulation with social media companies dramatically changed. It was a turning point, I think, in 2017 with Cambridge Analytica scandal, and after that, different big problem that happens with the Brexit, and so the interference in democratic system, and also the interference during the French presidential campaign, more recently during the COVID, and all the problem of disinformation that was dispatched through the use of social media company. So in this context, at least inside the European Union, 3 countries decided to regulate, in fact, social media companies, which was France, Germany, and Austria. But this regulation, all of them have been challenged in front of court, and some of them have been invalidated. And it also creates a problem for the European Commission because this very fragmented legislative response in Europe, in fact, fragilize the idea of this single market of digital services. And to fix the problem, the European Commission drafted this legislative proposal, which have finally been adopted in 2022, the Digital Services Act, the DSA. So, having this in mind, what we can say is that we had this hard governance turn in the European Union with the Digital Services Act. And in fact, this regulation at the end replaced, in fact, the state over social media companies. More precisely, in the study that we did, that we write for the Office Federal of Communication of Switzerland, we make this comparative analysis of what have been done through the different legislation. And I think it's probably an interesting point for the topic of today. What we can see is that indeed there is a very common understanding of what kind of solution should be deployed for regulating social media companies in terms of content moderation. And this solution is related to procedural mechanisms or procedural safeguards that I was mentioning in the beginning of my intervention. More precisely, what we can see is that there is a couple of rights that have to be guaranteed. So the right to be informed, so this is the notification obligation, the right to get explanation regarding moderation decisions, so the obligation to provide a statement of reason for social media companies, and also the possibility to appeal inside the social media governance system, which is also named the right to a second look. Among these different legislation, the European Union with the DSA brings an extra guarantee, which is this possibility of external appeal, which is put in place in provision 21 of the DSA, and which is in fact a new kind of dispute settlement that could be put in place by private organization, but would have to be certified by the Digital Services National Coordinator. So, from just to mention this question of regulation studies perspective, what we have seen that we have a shift from the first offline regulatory model, where in fact the regulator was the state and the target were the citizen, the user of the platform, and then in the online environment now we have in fact the regulator, which is still the state, then intermediary who are the social media companies, but also this new architecture that the new bodies that we should see in the future with this dispute settlement bodies and flaggers trustees and all those kind of tools that have been put in place. And finally, the target, which is still the citizen, the user. So at the end, so should we be confident about the solution that have emerged right now in the European Union? I think one first point that we can say is that indeed we can confirm that there is this infusion of human rights based approach in the European legislation. But on the other side, what we can also notice is that, in fact, now we have recognized, I mean, when I say we, I mean public authorities have recognized the complete dependency to a social media platform. This dependency is due to the very monopolistic dimension of social media platform and also the technical complexity which is related to the way of working of this platform. So in this context, the European Union chose this co-regulation approach where they made social media companies partners in the policy of the freedom of expression. And on one side, probably it's a very careful option and solution that have been taken by the lawmakers. But on the other side, there is, I think, a very clear problem of independency for a regulator who, in fact, have to count on its intermediary to guarantee the respect of human rights. I thank you for your attention.
Thank you, everyone. So this was a very interesting, fascinating journey into the complexity of this subject, starting with the Oversight Board as a tribunal to decide on content moderation cases. And we have already seen, Sabrina, you led us to it, that independence of this tribunal is an issue, as well as which standards it should apply, and also whether its decisions are enforced. You say yes, but what about the recommendations? And Marie, you have taken us on a ride into the question which standards to apply. You have touched upon this as well. The difficulty, which standards to apply, national laws, human rights laws, withstanding case law, and also you gave us a short overview of the connection between liability and human rights, freedom of expression, and that you could take the route of making social media companies liable, responsible, but then what about their freedom of speech? And at the end, Sophie, you took us into the regulation of content moderation in the EU. Very interesting. You pointed to this decision either to go the route of substantive law or procedural safeguards, user-dependent, and that the DSA actually chose the procedural safeguards, introduced new instruments like the out-of-court dispute resolution process. The question is whether the Meta Oversight Board would be one of these institutions serving in this role, and also you pointed to the outsourcing of a state responsibility to private entities in actually the implementation and enforcement of fundamental rights, and the question being whether through either the voluntary commitment to human rights, such as through the Oversight Board, or through an obligation, we can reach an indirect horizontal effect of human rights in the social media space. So we touched upon very difficult but very interesting questions here, and I'm eager to open the floor for question and answers. So you go ahead. Who would like to ask the first question? Yeah.
Thank you very much for this great panel. My question is for Sabrina. I would like to understand a bit more the nature of the relationship between Meta and the board, in the sense of the decisions of the board are binding to Meta. Is there a contract that makes them binding, or is it just a soft commitment to implement them?
Can you hear me okay? Yeah, perfect. Just so I understood your question correctly, you're asking whether the obligation from Meta to implement our decisions is contractually binding, or whether it's just kind of a soft commitment. So it is contractually binding. We actually have a contractual agreement with them. It's also, if you are interested, you can look on our website, in our charter and our bylaws. It's actually legally written out exactly the kind of commitment that Meta has made to us, in the sense of, for the decisions on discrete pieces of content, whether to remove that piece of content or whether to keep that content on the platform, that specific piece of content, the decision on that is legally binding on Meta, and it's a contractual agreement that we have.
The board could potentially sue Meta for non-complying with the decision. Right?
It's a good question. I don't think that we ever have it. I mean, theoretically, potentially we could, I suppose. I don't know if I'm in a position to speak to that, but there has never been a situation where Meta has disagreed to implement our decision. It's typically, as I kind of discussed throughout my presentation, it's more the gray areas around the implementation of the policy recommendations on how to modify their community standards and their policies.
Thank you.
So thank you very much for both presentations from Marie-Caroline and Sabrina. And for Sabrina, I have in fact two questions, because you present in fact the situation where Meta have removed or allow a post, but there's other techniques that can be used. And can you control all this shadowing process that they can use? I mean, with content with posts that have been online?
For sure, and thank you so much, Sophie. That's a great question, because I've only kind of spoken about the binary decision of to remove a piece of content or to keep it up. And one of the objectives of the board is to expand our scope so that we can implement different content moderation processes. So for example, recently we've expanded our scope to include implementation of warning screens. So a very good example of this is in many sub-Saharan African countries, we were seeing a lot of pieces of content that involved very violent and graphic video footage. And the reason for this being there's not a very strong media ecosystem or democratic media ecosystem in those countries. So a lot of civic journalists were taking video footage themselves on their phone, and these pieces of content were being removed from the platform because it violated Meta's policies on graphic and violent content. And so we've now expanded our scope to recommend that Meta can apply a warning screen to mark as disturbing or to mark as sensitive in certain cases. So beyond just should Meta remove a piece of content or should Meta keep the content up, we've also been able to recommend or tell them that they should implement a warning screen. The one criticism of the board that I think is quite legitimate is that we aren't able to necessarily tell them that they need to modify their algorithm or to demonetize or delist or remove a cross-check or verification. So those are not within the jurisdiction of the board, but we are constantly trying to expand our scope. So hopefully one day they will be in purview.
I have a second question for you regarding the DSA, because I think one of the questions that probably many legal scholars have in mind is, would the Oversight Board apply for be certified in Europe as this dispute settlement bodies? And so can we imagine that you extend your jurisdiction to others' platform?
So unfortunately, this answer is going to be very brief, which is I'm not allowed to say quite yet, but if you watch our space, you will find out more information about that. But I don't think I'm allowed to say what it is that we have planned. But we have been very involved and been watching the evolution of the DSA over time. And as I mentioned earlier, we are a very early model or an example of how this out-of-court dispute resolution bodies can look. So I will just say that in the future you'll have more concrete information on that.
So Sabrina, there is a question online for you. So are all cases reviewed manually by the Meta board, or is there some automation involved in the process? Yes, that's a good question, because you mentioned that there were so many cases, millions of them, and I was just wondering how you could do it. So yeah.
Yeah, so this is actually my day-to-day job. So it's actually a mix of both. So I will say that the majority of the work is done manually. However, we do have filters in place. So as I mentioned, I think at the top of my presentation, a lot of the appeals we receive are very non-meritorious, to the point that I would say they're like spam. So we get a lot of F you this, F you that. So we do kind of have spam filters in place to kind of remove the non-meritorious and kind of harassing cases. And then from there, we do have a pretty robust team of individuals, myself included on that team, who manually review the cases and make decisions. And we go through a very thorough kind of process of evaluating those cases. So what country is it in? Is it a language that we haven't examined before? How many views does that piece of content have? Is it addressing a potential policy gap? So most of that work is done manually, but there are kind of automated filtration mechanisms that we can use to try and sift through and filter the cases that are not warranting attention.
Thank you. Thanks everybody for a fascinating panel. I have a question about the board, but I don't want to single Sabrina out. So it's mainly addressed to you, but I'm of course curious to know what everybody thinks about this. So when I look at the community standards, I see very much this universalist ambition of having one set of rules that will apply to meta users everywhere in the world. And human rights law, of course, also has the same ambition of being a regulatory body of law that applies to every human being, right? And the Oversight Board has, to a certain extent, a guardian position of ensuring that these community standards are applied in compliance with human rights law in every country where Meta provides services. Now, one thing that we mentioned with Anja this morning, actually, is that a regulatory framework at the national level for content moderation might be increasingly fragmented. And in the future, you might have some legal systems where these community standards are enforceable, and so you can moderate and remove lawful content if it's incompatible with the community standards. But other legal systems where actually those community standards are contractually unenforceable because platforms are prevented from moderating lawful content, even if it's awful and hate speech and so on. So in this potential future of fragmented national regulation, how would the board navigate the tension and maintain its global role, so to speak?
Is this on? Okay, yes. It's a great question. I just wanted to make sure I understand it. So, yes, yeah, please.
Because we have talked about it this morning. So in the US, basically, you would be considered, a dumb pipe, and more like a utility company, basically shooting information back and forth, like a telephone company. Whatever is talked on the phone is not your responsibility. And now we have cases pending in at the Supreme Court where the question is, or where you platforms actually raise your First Amendment rights, your right to speak as a private entity. And we have in this US the situation of must carry laws that are actually in the pipeline, and here we have the content moderation consensus in the EU, and as you said, the fundamental rights that could be actually applied through the terms of service. So how do you navigate this terrain of being a dumb pipe in one part of the world and considered more or less like a journal, or let's say having a moral responsibility to edit the content?
Thank you. That's a great question. I will do my best to answer. And also, of course, I don't want to monopolize the conversation. So if you would like to add anything, or Marie-Caroline online, please, if you have anything to add, please do. So I'm going to do my best to answer that question. I will preface it by saying that I'm not an expert in transnational or international law. I guess the challenge is something that it's always been there. So part of the major criticism, not necessarily of the board, but of Meta generally, is that it operates in so many different international markets, but it uses one kind of global community standard guidelines to moderate everyone everywhere. And of course, there are nuances to that. So for example, Meta itself has different market experts in different regions, specifically to ensure that there's contextual analysis that's done on a piece of content before it's actioned. And I guess the reason that the Oversight Board has decided to use international human rights law is that it kind of provides this overarching framework. I don't know if that answers your question, but I hope that it gives a lens as to the fact that international human rights law is trying to get around the different kind of national issues by using one kind of internationally recognized or universally recognized framework.
You want to add something, because at the end of the day, it's also balancing rights, right? Meta has its own right of speech and expression as a business entity, at least in the US. And in Europe, we have the user rights of expression. And if we talk about human rights, it's always a balancing question, right? And we said, are human rights an effective standard to guarantee these fundamental rights? If you want to say something about it.
Yeah, thank you very much. I mean, I will change a bit the orientation of the question of the topic of the question, because it's true that we know that there is some strong distinction between freedom of expression and free speech, and in the continental world, which is still very dominant today. But what we show in the paper that we publish about, because we did a content analysis of community standards of Meta Facebook, and so what we did, we said, okay, so considering that you have to, not you, Meta has to justify why they are removing content, they have to have a legal basis for that, and they are using the terms of condition, and in the terms of condition, what they are using, in fact, is the community standards. So, from a European law perspective, but it's a common understanding with the UN human rights bodies. In terms of, when you have a restriction to a human right, you need to have to respect the principle of legality, and the principle of legality means that you have to have a very clear expression of what you want that are not allowed. So this clarity requirement, in fact, have been analyzed and deconstructed in different elements by the European Court of Human Rights, but also by the Human Rights, the Committee on Civil and Political Rights of the United Nations. And we say, okay, let's use this requirement and check, in fact, if community standards comply with this criteria. And the answer is no. The answer is no. So then, what does it mean? And why it's important? It's important because the DSA, in fact, in Article 16 of the DSA, they include the clarity requirement of the principle of legality. So it means that social media platforms, all of them, have in fact to edict community standards or community guidelines, depends on which we are talking from, and they have to fulfill this requirement. But right now, I mean, the biggest one, Meta, doesn't complain. So, not completely, not completely. So what does it mean? It means that if, in the case of Meta, if they want to complain with the DSA, it means that they have to amend the community standards. And so they will have two options. Either they will say, okay, we change because the American English version is the first one. The others are interpreted in the link with the American version. So it means either they change the American version, so it means that the European standards will be extended to the rest of the world, or they go in this logic of fragmentation of the internet, and they say, no, we will just adapt the European national language version, and that's it. So I don't know if you have information about what will be done.
So I don't have information on what will be done, but I do want to add a comment to that if I can on the legality aspect and whether the rules or community standards are clear. So as I mentioned, in our case decisions, legality is the first thing that we look at as part of Article 19 of the ICCPR. One thing that I found very interesting in respect to what you just said about requiring them to make the rules much clearer is that it's something that the board has pushed on, not just with Meta, but also just generally a lot of civil society groups have pushed social media companies to publish more information about their internal implementation standards. For example, what designated individuals or organizations are on their list of individuals or organizations that you cannot speak about or represent, so Hamas, for example, or terrorist organizations like that. Many people have asked for Meta to publish the list and to make the rules more clear so that users know what to say and what they can't say. Typically, companies have been very reticent to do that because their reasoning is that if users know exactly what they can and cannot say, bad actors will use that very clear information to circumvent the rules. So I'm very curious to see whether there will be pushback on that specifically. I can't speak to whether, I don't speak for Meta ever, but I'm just very curious to see whether Meta or other social media companies will push back on that, because their stance has always historically been that we will not publish very granular details or very, very specific guidelines, because bad actors will exploit that clarity to circumvent the laws.
There was also maybe another online question.
Sure.
Yes. So what are your views on term of service removal of disputes from the common court system to arbitration courts that have traditionally been more favorable to corporations?
Would you like me to repeat it?
Yes. So
Yes, maybe, yeah.
there are disputes dealing with term of service. Is that it?
Yeah,
I guess.
so if I open up the question a little bit more, it's kind of the outsourcing to basically from state tribunals to private ordering, to private institutions, private justices, so to say, and which are traditionally leaning more towards the corporate side. And I would like to open it a little bit and talk about the power balance. Perhaps we always assume it's a contractual relationship of equal partners, and here, and this is, I guess, the reason also for the DSA injecting some regulation into how to design the terms and services, how how that can be, how this could lead to a fair outcome if they're traditionally leaning towards profitability.
Well, I'm quite skeptical about private dispute settlement bodies. I'm sorry I didn't come yesterday with e-sport, because I think sport is a very good example of private dispute resolution. And in terms of human rights, it has not been a clear success. And I think that everyone have heard about Caster Semenya case, and this kind of cases still arrive at the end at the European Court of Human Rights, which means that private bodies probably need to upgrade their knowledge or their expertise on human rights. So I understand that the European logic to go through in direction of these private bodies, because in fact, the online activities activities online are so huge, so diverse. We had a look yesterday afternoon on the digital service data center, and there was 14 billion of statements of reason that have been given by the 17 online platforms that are today monitored by the European Union. 17 billion. Just unimaginable. So what I think also, and I want to come back on the point that you just made before, is that in fact, I think all the discussion, should you have more clarity in should Meta have more clarity regarding the community standard? One hypothesis that we have as researchers is that in fact there's the way that the community guidelines are drafted are also due to the automatic dimension of the process. And in fact, it's really written in a way black or white, and that's really like an algorithm needs to be programmed. So I don't know. If it's not also part of the problem of this legal clarity that is missing right now in the community standards, because in fact they need it to be operationalized through automatic system, and so it's difficult to put more nuances on this point.
That's almost a good segue in the next session, where we will talk about algorithms as content moderators. But let's say, picking up the last question, if you are not trusting private arbitration, private ordering, is there a way to involve users more, or let's say decentralize content moderation? We talk about this in the afternoon, but let's say generally, how could the user be involved more? You have experience in involving users, in content moderation?
I think we are coming always to the same point. You have this other institution in the DSA, which is the trusted flaggers. But there is a problem of operationalization, of implementation of this new bodies. And in fact, NGO are, we think that NGO should be the first one to do that. But in fact, they have already so much work that they can't do it. So either we'll have a completely new ecosystem that will emerge with, a new business in terms of content moderation, and then we have to ensure that we can trust such a private new governance. Either we say no, in fact we want to focus on the substantive rights, and because now we choose this procedural approach, but maybe the other way should be also consider it.
Sabrina, you think that's realistic because you are an expert and you are a case manager, and these are very complex decisions. You think the user actually would deliver good results in terms of veracity or accuracy of the decision?
Yeah, that's a great question. Just based on the diversity of cases that we see in the user appeals and statements, I think users have a propensity to really make their case. So I think so as well. One thing I wanted to add, it's not about Meta, but I think just from an industry perspective, what I find really interesting when you're saying kind of putting the power in the hands of the users more, I think it's Snapchat that actually on their trust and safety board, they've hired, I think it's 6 15-year-olds to actually advise on their content moderation and trust and safety panel, and I think that's really innovative. You know, with the Oversight board, we have a lot of very accomplished individuals who may not understand what it's like to be a teenager using social media today. So I think putting the hands of users who are using these platforms daily, as with Snapchat, I think it's really innovative and really interesting.
I don't know how much time you have, but Marie, you want to say something about that because you touched upon substantive law and. Yeah.
Yes, sorry, it was more on the question previously treated in response by Sophie mainly. What I found interesting is that privatization of law, of public actors is already there, because when we see how Meta and the Oversight Board are working, we see that there is the international law, international human rights law standard, and the platform policies, as Sabrina stressed it, has to compel with this international law. So the Oversight Board has a two role, I think, cited. On legal point of view, the Oversight Board verifies the transposition, kind of the international human rights law into the platform policies. And on a more political point of view, the Oversight Board is legitimating the position of Meta to transpose and apply fundamental rights. So here we see that there is kind of a double mission of the Oversight Board, and it's really interesting because, yeah, like I said, the privatization is already here. So whether the individual should be implied in this mechanism, I think it's almost there, because of course if the rules are contained in the platform policies, it binds the users. So I think that it's a matter of time, of perspective, or a way to present things, to see the individual as a part of the mechanism in the content moderation.
As I understand, we are out of time, so we described the landscape very well, I think. Thank you so much for your insights, and we're eager to learn more about the DSA and the automation of content moderation next. Thank you very much.
Thank you.